Hello, once again, this is Antonio, and I'm coming at you with another exciting video. Now, you know I got to keep dropping heat. On this channel, we're going to keep dropping the heat. Thank you for all my new subscribers. We just hit 5,000, dream come true. Now, in this court case that we're going to show, the mom is withholding custody from the dad because she's afraid that dad is going to come and take the child from her home. I will say this: you need to watch who you have children with because these types of things happen all the time. Nevertheless, let's go ahead and drop the video.
My client is the fact that he hasn't had any parenting time. Miss Boone, today's Friday. Would it be possible for Andrew to pick up Maddie at 6 p.m. tonight?
No, but he can stop by whenever. Whenever I'll make it available, he can stop by anytime.
Well, isn't 6 o'clock anytime?
Yeah, he can come by, yes, but he cannot. I don't want him to pick her up right now.
Why?
Dad is extremely concerned about the lack of participation by mom.
After our initial meeting with you, we did go ahead and file the motion that's before the court today, that being the motion on parenting time, custody, and child support on behalf of my client. Because the issue of custody really was not addressed in the previous motion filed by Miss Boone, and we wanted to preserve that issue. Currently, the only order that's in effect before these parents is one that does speak to parenting time, but it's a judgment of support, which would provide that parenting time would be evenly split 182.5 overnights per each parent. Now, there remains the issue, it's very concerning to my client, is the fact that he hasn't had any parenting time with the minor child since before Halloween this year. We've been working through the court system. We want to get everything in place. We need to get a custody order in place. We need to get a strong parenting time order in place. But ultimately, we're extremely concerned about the lack of participation by Miss Boone with parenting time. Now, I would note that the last time we were before you, you did state that parenting time was to be reinstated, that Miss Boone was to cooperate with my client.
And if she didn't, the consequences would be that could be used against her in the parenting time assessment.
Yeah,
because that is one of the main factors, and if there's not, that also can switch custody if she's not careful.
Yeah, no, I gave Andrew multiple times as I sent it to you.
Well,
for him
I'm
to
gonna get to
Maddie.
Allison. Okay. I'm gonna get to you in a minute. Let Mr. Bancroft finish first, and then we'll get to you. Okay.
I'm sorry.
I would state that my client has made himself available, has communicated with Miss Boone regarding parenting time. She has not cooperated with that. As a matter of fact, when we were before the referee, just within less than a month ago, this issue was addressed then, and it's the same thing. She's stating that he's available, but it has to be completely on her terms, and that it's not to include overnight. She even suggested that it would be some sort of supervised parenting time at that, which had previously never been a factor before. Right. We have provided several pieces of evidence, including medical records, proof that my client's payments for the child, that being involved with the child since the child's birth,
right.
Just witnesses, identification of witnesses. We're ready to move forward with an evidentiary hearing in this matter. And quite frankly, I'm trying to find a way, if there was something we could get some teeth behind, that we could file a motion for show cause against Miss Boone for her violation of the parenting time. Granted, it's kind of an oddball situation with the—
Hold on, what court order is she in violation of?
Well, the judgment of support, the one where it does,
which says that it's by agreement.
Yeah,
so she's in violation of no court order.
And
there's got to be an agreement. Yeah,
that is the problem, and that's why we haven't done that yet, and why we want to take these steps. But we want to, as expediently as possible, get to a position where we have an order in place, so we can find the best interest of the child, and my client can start exercising parenting time again. Thank you, Your Honor.
Yeah,
this motion is kind of premature until we get the front of the court report. we're not doing anything. I mean, otherwise, why would I have sent it to the front of the court?
I
And I
understand.
sent it for legal custody, parenting time, and child support, which, as I explained then, pursuant to a case law, Sims versus Verbrugge, which is a Kent County case that reviews these orders, it does note that physical custody has already been awarded by court order. Even though it was without prejudice, you'd still need a change of circumstance in order to grant a custody request. But you didn't need one for legal custody because this court order does not address legal custody. So this court sent it for legal custody, parenting time, and child support because obviously that's what it needed to do. And so this motion is premature. I did not find a change of circumstance then, and I do not now. Without further information, I want to see the front of the court report. Let's see what that does first. The quickest way you're going to get to that is if there's an objection to the front of the court, then we grant a hearing. But I'm not granting anything until the front of the court report because you may both like it. You may both hate it. They do settle about 80 to 85% of our cases because what comes out is normal. And I always warn people, physical custody is a name. I can grant him physical custody and grant him 0 overnights. If you want to know what physical custody is defined at. What's important is parenting time. Okay. Parenting time is when you get to spend the time with the kids. So I can grant you every other weekend and say you've got physical custody. Heck, we used to play with it too and say you've got primary, you have secondary. What does that mean? Not sure. Okay. Because what matters is legal custody. Legal custody is what entitles you to certain things. That's automatically granted to a husband and a wife. It's not necessarily granted to a child born out of wedlock and the father. What happens under the statute is if you sign an affidavit of parentage, on that affidavit, you have presumptively given the other side legal and physical custody, and you signed it as a contract. But again, it's without prejudice, which is why we can review it. I want to get something started. I want to get the parenting time going. And as I warned her before, that can be used against her. So I suggest both of you keep what you've attempted and all the paperwork, all the texts and stuff. You might want to print them out because they may become relevant as to who's doing what. That's why I always tell people keep the receipts on this stuff because it's important. The court may need to look at it. We may not. But I'm afraid I'm going to deny it at this time, Mr. Bancroft, without prejudice, because we need to you're right, we need to get moving forward. Unfortunately, I think I also warned you in that November that 7 of our 11 holidays happened between November 11th and January 13th. So the court generally gets backed up during those 2 months and everything gets thrown up, just put out about 4 or 5 weeks. So you should be getting that report. When did you meet with the front of the court?
The 8th of January.
Okay, so give them about 4 weeks to 5 weeks and they'll type up the recommendation. They will send it to you. If you both agree with it, it will become a court order. If one of you objects to it, we will set a hearing. Okay. As a matter of fact, if that hearing needs to be set, let me see if I can circumvent this one. File whoever wants to object, file the objection, contact my clerk, and we will just automatically set it for a hearing. You don't have to come in for a motion like this. But it has to come with this, Allison, because I can tell you this morning. If we do go to a hearing, you will be treated like an attorney. Okay. We're going to talk about at some point, we're going to talk about who would go first, and it depends on what's being recommended and who is objecting. So we'll make a determination as to who goes first. You'll be allowed opening statements, which is basically welcome back to English class. It's a summary of your paper. I need the bullet points, the topics, and then you'll be allowed to present witnesses. Evidence comes into court through a witness on the witness stand. Evidence does not come into court as a stack of papers. Each paper has to be reviewed by a witness under oath, said, hey, I drafted this, or I got this off the internet, or this is what my research, mark it as exhibit 1, any objections, then it gets entered into evidence. Otherwise, the court does not look at it. To give you an example, I had somebody that presented 18 exhibits about 6 months ago. They entered 4 of them. And when I made my decision, they were like, well, why are you making that decision? What about? And I'm like, you never entered that into evidence. The court never saw it. So please understand that my abilities are limited by the testimony that you give me. I can only make a decision based on what you guys tell me in court, which is why we do the front of the court first, because they can hear all of your stuff. Hearsay rules do not apply. The rules of evidence do not apply. They get to hear everything, see everything. Whereas if you're in court, you either may forget to give me it, or it's not admissible because of certain rules.
Okay.
So yes,
What
my decisions can be very limited.
what would be considered admissible? Like, can you give me an example?
That I can't give you 3 years of law school in a
Okay.
5-minute
Okay.
master's.
Okay.
And this,
I'll
Mr.
figure it
Bancroft will
out.
be able to, yeah, Mr. Bancroft can, talk to his client about this, but that's why I need to talk to you,
Oh,
because that's what warning this comes with. Is if we
okay.
go to court for a
Oh, I'm
hearing,
sorry.
you are treated as an attorney.
I
And
do.
we would discuss whether you guys would want that hearing in person or on Zoom. That's up to
Okay.
you. I do it either way. So far, 90% of the people prefer it by Zoom because it's just easier for everybody. They don't have to drive down to the courthouse. They don't have to have their witnesses come down. Their witnesses can just call in. So
Oh,
that
okay.
makes it a
Yeah.
little bit easier. All right. I might suggest that you consult an attorney though, Ms. Boone.
Yeah.
Whoops.
I've been talking to one.
Yes, Mr. Bancroft.
I know it's probably not necessarily appropriate to use this setting, but we do have the parties all in one spot between you. May I inquire of Miss Boone regarding trying to set up a parenting time
Yes,
session
you
at this point?
Yes, you may.
Miss Boone, today's Friday. Would it be possible for Andrew to pick up Maddie at 6 p.m. tonight?
No, but he can stop by whenever. Whenever I'll make it available, he can stop by anytime.
Well, isn't 6 o'clock anytime?
Yeah, he can come by. Yes, but he cannot. I don't want him to pick her up right now
Why?
because he doesn't have to give her back to me, and he knows that.
Yes, he does, because you're the only person that has custody right now by law.
So when I went down to FOC, they said that he does not have to give her back to me because there's
Yes.
no
You are
order
granting him permission to see the child, and I'm telling him, just as I'm telling you, he should be able to see the child. And Mr. Hess,
Yeah.
you follow the agreed times. If she says 6 to 8, you bring the child back at 8. I mean, she's got sole legal and sole physical custody.
So if
She's the only authority right now.
I feel comfortable. Thank you for saying that, because what I was told at FOC is no cops will help me if something
Generally,
came
cops
down
won't
to
help you
it.
even
No,
with it. The police will not help you generally even with a court order. They don't like to get involved in these matters. It doesn't,
okay.
they prefer to just say, no, this is your problem. This is a civil case. All right.
Right.
So that has nothing to do with whether you have orders or not. That has everything to do with police and what their job is and what their job isn't.
Right.
And their job
Okay.
isn't acting as parental police. So,
Okay.
but that's why I said you guys have to, parenting time is by agreement. If somebody breaks the agreement, that's a problem. And that goes against the other person. Because if somebody breaks the agreement, I generally am reluctant to give them any parenting time. But
Right.
that comes with the warning to him. Your
Right.
warning is if you don't give the child at all, that can be held against you because you're not cooperating. And if you're not cooperating, you may not get custody of the child eventually.
Right.
Okay.
Okay. Okay.
Mr. Bancroft, if you'd like, we'll put you in a breakout room with all 3 parties. 'Cause I've got other motions. So, I mean, this isn't a settlement
I
negotiation.
understand. I appreciate that. And I appreciate
Yeah.
you taking the moment. I kind of realized I extended beyond the scope of what we
No,
were.
that's okay.
I appreciate you.
I'm just trying to get them through this. That's all we're
Understand.
trying to do. I mean,
I
if you get a
appreciate
child,
your
I do.
previous knowledge of how these cases work, and I
Yeah.
appreciate your
Well, I've been doing this for
your
almost
help with
30
that.
years. It's not previous knowledge. It's just become ingrained.
Yes. I would appreciate a breakout room.
Yeah, we'll get
That'd
you a
be
breakout
excellent.
room for all 3 of you, and then please come to some kind of an arrangement. And if you can, just put it in writing. That way you know times of pickup and drop off. Let's
Okay.
get some time going with this child. The child knows him. She was seeing him before Halloween. So, alrighty,
Yep.
good luck.
Thank
I like how the judge stepped in and made sure that the dad received parenting time with his child. The mom, she's frantic, thinking that the dad is going to take the child when all he wants is equal love, just like she receiving. I think a lot of ladies, and I'm not saying this from a sexist point of view, but a lot of ladies think because they birthed a child, it's their child. Even the judge say you're a child, or something like that. But it's y'all child, it's our child, or that's your child and my child. It's not just the mom's child. But nevertheless, this is Antonio, Team Tiggio. Please like, comment, subscribe, as we'll be coming to you with more videos in the future. And once again, we will see you in the next time.